the air is very clean. There's no pollution. So you're getting the best of clean air and a slight salt effect for the fish when you're at a restaurant right along the coast.
Mm-hmm.
This is true at the fish market. The air is very clean. And I have allergies, and I always feel great when I'm there because I can breathe.
I think it's a combination of the air, the salt, the food being fresh. All of that probably adds to the experience and making it just taste all around as best as it can.
Yeah.
It's living the life.
Well, it's a great. If I could live there, right next to the restaurant, I would. And they have some condos there.
Okay. All right, Pete. So we are going to get started right now. We have, I think, over 50 people online at the moment. So we're going to get started with these slides. Hold on one second. So we want to thank everybody for joining us who's out there in the webinar world. This is a presentation through CCIM Los Angeles. My name is David Chen. I'm going to be moderating, though not too much. I'm just going to be introducing and dealing with the Q&A afterwards. So I'm David Chen, and I'm the past president for the CCIM LA chapter. And today we have Pete Wittlin here, attorney for many years, and he will be speaking on a very interesting topic for us today that's going to be near and dear for us in commercial real estate. So as you can see on the screen, we have some of our sponsors that we just scrolled through. We want to thank them all for sticking with us this year with COVID and with all the changes we've had going on. So, right now, hold on one second. Can we go back to the introduction screen for Pete? So yeah, we want to thank Pete for coming. We want to thank the sponsors, like we said. We're going to also just hold the questions for afterwards, and feel free to just post the questions in our Q&A box, and we will get to it at the end. So this presentation should be approximately 45 minutes or so, give or take, and we'll have about 15 minutes afterwards for Q&A. And if Pete will permit, and if he has some extra time and we have extra questions, we'll try to get through them as much as we can. All right, so a quick introduction for Pete. Pete Wittlin has been practicing real estate business and bankruptcy law in Orange County since 1979. So, he has a ton of experience. He is a 1976 graduate of Pepperdine School of Law in Malibu, California, and a 1971 graduate of Washington University in St. Louis, where he obtained a Bachelor's of Arts degree, majoring in American and European history and minoring in English literature and composition. He is a former teacher, having earned a secondary teaching certificate on a master's level from the University of Bridgeport in Connecticut in 1972. So as you can see on the list right here, Pete provides the following legal services for you and your clients. This is pretty expansive. So he deals with appeals, bankruptcy, reorganizations, business formation, business dissolution, business litigation, contract preparation and negotiations, mediation and arbitration, real estate litigation, residential and commercial sale and lease negotiations, and tax litigation. So I want to welcome Pete to our webinar today. And we've watched him and was introduced to Pete through another past president at CCIM, Rubik. And he loved the presentation so much that we asked Pete to come join us. And I know he has a lot of very recent information. Since things have been changing so much during the COVID-19 pandemic, that it's constantly changing, so we're constantly trying to keep up. All right, so Pete, if you can on your end, get your share slides going, and we will start it up.
Okay. We're talking about commercial evictions in California during the COVID-19 epidemic, present law. Can you hear me?
Yes, we can hear you.
Good. All right, and this is dated today. It's up to date. Today we focus on current commercial eviction law and practical solutions in California. A, evicting business tenants, negotiating to forgive or reduce rent, early termination agreements, and bankruptcy court protections of tenants and their guarantors. On March 17, the governor, let's see where we are here, moratorium law, left-hand column. On March 16, Governor Newsom issued Executive Order N-2820, imposing a moratorium through May 31st of this year against evicting both commercial and residential tenants in California. Let's see, March 17th, okay. On the right-hand side, it says, on March 17, following day, he issued an executive order, N-3320, the Safer at Home Order for Control of COVID, ordering many businesses closed to the public due to the pandemic. I have a number of clients that operate restaurants, and they were affected by this. On April 17, the California Judicial Council responded to the governor's moratorium by enacting Appendix 1 emergency rules, barring the filing of complaints in court for unlawful detainer to evict both commercial and residential tenants for non-payment of rent or otherwise, this was expansive, for at least 90 days after the governor may end his moratorium. That was a shocker. It says on July 32, it's actually July 31st. The governor, per Executive Order N-7120, extended his moratorium from May 31st to September 30th. And that's, of course, now expired. On August 31st, the California legislature passed COVID-19 Tenant Relief Act of 2020, extending the moratorium on residential evictions to March 1, 2020. Now, continuing, we've got some pictures here of buildings. So at present, there is no moratorium on commercial evictions in California. It ended August 31st. That's important to know. Landlords can now sue tenants. Commercial, they cannot do it for residential until after February 1st of next year. We're going to talk about commercial. Defense to commercial evictions. A tenant may assert in its answer to the UD complaint the affirmative defense that due to the governor's shutdown of the business, or as a result of the virus, it has been financially unable to pay the rent, that due to frustration of venture or impossibility of performance, A, the tenant should be relieved of paying the rent in whole, and that the lease should be deemed canceled. This is what the tenant would assert as an affirmative defense in its answer to a UD complaint. And that answer has to be filed within 5 days after the complaint has been served on the tenants. It's a short time. 5 calendar days. It's no longer 5 business days. It's a new rule in California. No longer 5 calendar days. So it may be as much as 8 days if it's a 3-day weekend, legal weekend. The tenant alternatively says, well, I should be excused from paying rent until such time as my business income becomes sufficient to pay it. So I should get out of it, the lease, or excused partially. There's good case authority for this defense known as force majeure or act of God. Yet the defense extends to human acts like governmental intervention, presumably a moratorium on evictions, and arguably to tenants' inability to pay its rent due to the virus-caused reduction in the tenant's income. So it's not mere closure. That's one defense. That's impossible to perform if the governor shut me down. But if I'm open, but the virus has knocked down my rent, I am entitled to relief according to these affirmative defenses. Tenants need to know that. In California, the court test for determining if performance may be excused is whether, under the particular circumstances, there is such an insuperable interference occurring without the party's intervention as could not have been prevented by prudence, diligence, and care. And there's a case called Horseman's on that. I've given you the site. That's a 1992 case. Hence the language, frustration of venture or impossibility of performance for the affirmative defense. Let's move on here. All right. Negotiations. Tenants' counsel may threaten to assert the force majeure defense or a bankruptcy filing to create negotiation leverage for tenant to obtain from landlord a full or partial rent forgiveness or rent reduction or termination of lease. Landlord with no incoming rent has a cash flow problem and may need to cut its losses and restructure the lease rather than simply evict the tenant. Landlord realizing that with the ongoing pandemic, that because the prospect of finding a replacement tenant is poor, relatable market rent has been greatly reduced. A permanent rent reduction agreement, essentially pegged a tenant's present and prospective income as the virus may fade over the next 12 months, may make commercial sense for both sides. A starter agreement forgiving accrued unpaid rent may grease the settlement wheels. Tenant's position is, landlord, you can't get blood out of a rock. I'll just go BK if we can't work this out. This may be enough to encourage landlord to agree to an early termination with an appropriate payment of a few months' rent to landlord, and tenant is out, or result in a permanent reduction in rent with tenant remaining in possession. Bankruptcy. If a tenant files for BK protection, does not assume the lease's full term obligations, which is typical of not assuming, the lease is rejected and breached by the tenant. And landlord's claim in bankruptcy court must be capped at the greater of 1 year or 15% of the remaining term of the lease, not to exceed 3 years following the date of the BK petition. There's authority stated there. The cap applies to debtor's guarantor, a case called In Re Art, which I just reviewed this morning, get up to speed on that one, and it's true. The cap is so other unsecured creditors may better share in whatever assets debtor may have upon being liquidated. Okay, we'll get to our hypothetical here, so put on your thinking caps. Commercial landlord Webster, LLC, recently renewed its commercial lease for 5 more years with tenant Pickles R Us, a Costa Mesa located delicatessen, for which its president, Gary Guarantor, signed a personal guarantee. Pickles continues in possession, but has defaulted in paying rent for 4 months now due to the governor's shutdown of the business or the virus's reduction in Pickles' business income. Pickles' back rent is $8,000 per month. It owes $3,200 in back rent. It demands a full $3,200 in rent forgiveness and would like a permanent rental reduction of $4,000 per month until the virus ceases to interfere with its business income. Pickles closed for 3 months, has just reopens its doors to business. Thank you, Governor Newsom. Although guarantor Gary has available equity of up to $80,000 in his home to assist Pickles, Pickles cannot afford to operate for the next 12 months' time unless the monthly rent be reduced to $4,000. Pickles figures that within 12 months' time, the virus may be over and it will then be able to begin paying the $8,000 per month rent. but it's not going to be a while before it gets there. Webster threatens to evict Pickles. What should Pickles do? Well, contact an attorney first. Alternatives, early lease termination. Although an immediate early lease termination fee may appear attractive to landlord, it probably won't work because the prospects now of landlord reletting the premises and thereby covering for lost rent are bleak in the pandemic market. Landlord is going to hold on to that tenant. Landlord has a guarantor in Gary and his home's equity. So unless Gary decides to come up with the $80,000 now, landlord probably won't let Pickles out of the lease. So asking for an early lease termination is probably not going to work under the pandemic situation. What about number 2? Forgiveness of past rent due in a non-retroactive 12-month rental reduction. That would be ideal for the tenant. This may make sense to landlord, or it would start with regular rental income, although at 50%, which loss landlord could absorb for a year's time. Landlord may instead prefer a rent deferral agreement, i.e. after the first 12 months, if tenant's income is restored to pre-COVID level, Pickles would begin to retire the unpaid accrued rent. Gary guarantor may need to supplement the $4,000 per month rent by, for example, $2,000 to keep the landlord happy if this alternative number 2 is going to work. So that is attractive and dynamic, and there's room for negotiating that without filing an answer to a complaint, although it could be negotiated after. Let's move on here. Nice pictures. Litigation. Pickles and Gary may decide to roll the dice and not settle now and assert their affirmative defenses to rent in court. By the time the eviction case goes to trial, the parties may settle in light of Pickles' then threat to file for Chapter 7 and guarantor Gary being on the hook for 1 year's rent or $96,000. Now, the alternative is 15% of 3 years of rent of $288,000. That's $43,200. So that's less, and the test is whichever is greater, guarantor Gary will be on the hook. He being able to refinance his home to pay the $96,000 a landlord. That's a lot of money to choke on, but that's the reality in this situation here. Absent a bankruptcy court filing, Pickles may be on the hook for the remainder of the 5-year lease, less what Pickles may prove in court, landlord could have reasonably recovered by reletting the premises. So if by the time of trial the market is beginning to recover and landlord can reasonably obtain another tenant, the tenant here, original tenant, may decide, I don't want to go Chapter 7. I'll roll the dice and prove that I don't owe that much money to the landlord because the landlord can cover by reletting the premises. Summary. Although the eviction may be set for trial, there is plenty of negotiation room for the case earlier to settle, either with the tenant remaining in business or not. Okay, I'm done and I'm open to questions. David?
Okay, Pete. So we'll start with the first one that I think, well, we'll have to kind of cover. So the question is, I'm glad to be here. Is anyone offering MCLE credits? I don't know what MCLE credits are, but we don't offer credits for classes through CCIM. And second question from Shannon Marr, will everyone be getting a copy of this Zoom recording later? The recording will be on YouTube. It might also be on our website, I believe. But in terms of the slides, Pete, is there a way for us to get a copy?
There's no slides. It's just my handout.
Yes, this handout, I mean.
I believe Chelsea just emailed it to you.
Okay, so as long as we can, yeah, we will be able to disseminate these handouts. Okay, Shannon?
Yeah, we We did it twice because the one that we're looking at now, I sent that to you a few days ago.
Right. No, I'm just trying to make sure that we can send it out to everyone in attendance. So we will
All right,
be sending that out.
If you need another one from me, let me know and I'll email it to you again.
All right. Thank you. So next question is from Jason Luros. He stated that some local jurisdictions have enacted temporary bans on commercial evictions. So I think that was that came right when we were talking about the bans being lifted. So Pete, can you elaborate on that a little bit? What happens if certain cities have temporary bans?
They will control if there are. The ones I'm familiar with have been for residential. I'm not personally aware of any restrictions on commercial, but it's always a good idea to check with the city to see if they're still there.
Okay, great. And next question is from Greg Powlick. How does business interruption insurance affect the landlord and the tenant?
Well, it provides fluidity or liquidity to the tenant, and it diminishes their argument that they're unable to keep their doors open or pay the rent. So it has that negative effect. On the other hand, it keeps them solvent, and there's also the payback or paycheck federal program. So there are means of getting money from insurance, from the federal government, and also I'll touch now on three laws that were passed in California that help tenants. AB 1577 excludes from gross income Paycheck Protection Program loans that were forgiven through the Federal CARES Act amendments and the Healthcare Foreclosure Act of 2020. So AB 1577 excludes gross income. AB 1447, legislature authorized $1 million hiring tax credit program for qualified small businesses. There's a credit of $1,000 for each net increase in qualified employees up to $100,000. So write down AB 1447. These things help tenants. And the last one, SB 115 appropriates $561 million for fiscal year 2020-21. Includes $411.5 million to advance stimulus with $230.5 million to help jumpstart construction projects. So that's SB 115. So those are three laws from Sacramento that are also helpful, may also be helpful to tenants as far as getting some to tenants.
Okay.
So there's an attempt to mitigate the effect of closing down or the virus by these programs. Go ahead.
Okay. So in regards to the business interruption, if these tenants receive business interruption insurance, they're not obligated to use that money towards rent, are they?
I think they are.
They are?
Well, if they otherwise owe the rent, then they can't say, well, that money I just got is exempt. The court is not going to exempt insurance proceeds from their income and ability to pay the landlord.
Mm.
I mean, the landlord will now can sue for eviction, and he can levy on funds that he can find of the tenant, and that would include insurance proceeds, paycheck protection, any other source of funds that come in. That they're not exempt, to my understanding, from a levy by the landlord.
Okay, so like what you said earlier, it weakens their case if they're trying to escape paying rent.
Well, yeah,
for sure.
Well, as far as trying to escape, there is no escaping paying rent under the law. You can negotiate for it, but there's no law that says, well, in 6 months' time, you're only going to have to pay 50% of the rent because you can't afford to pay the difference. That's not going to happen.
Okay.
But the landlord has to be wise. If they push too hard, try to get blood out of a rock, the tenant can file Chapter 7 and limit the amount that is available to the landlord.
Right.
So that forces the landlord to have to compromise.
Got it. So Greg has a follow-up to that question. So he says, I have landlords that did not receive rent from tenants who receive PPP funds. What is their recourse?
Well, I'm not aware that there's any bar by a landlord from getting a judgment or even a writ of attachment, perhaps, over funds that the tenant has received. So if the tenant just got an $80,000 check and the money is sitting in the tenant's account, and the landlord may have a right to go in for a writ of attachment to have the sheriff seize those funds and apply them toward the back rent.
Okay, so they would have to go through the legal system and to deal with that.
True, but they can threaten, the landlord can threaten that and force a negotiation. If a tenant is sitting there with money and not paying a dime and just isn't going to do anything, the landlord has to get tough, threaten, and get the tenant to get off the tenant's duff and work out a deal. There's a lot of room for negotiation here if it's handled correctly by both sides.
Got it. Okay. Next question is from Bob Davis. When will courts review UD filings?
Immediately. There's no moratorium on them anymore.
Okay. So I guess they're starting up.
File a complaint with a summons today or tomorrow, and it's immediate. It may take the court a couple of days to process the paperwork, but within a week's time, you'll get your summons, and then you can serve it with a complaint. Got it.
Okay, and we have next question from Sharon Kars. Can Pete speak to subchapter 5 bankruptcies? And I would like to ask Pete to elaborate on the difference between subchapter 5 versus chapter 7 bankruptcies.
Subchapter 5, I don't know what that means. We have chapters 7, 13, and 11, and then there's a limited chapter 11 with easier rules for smaller cases, but I don't know what subchapter 5 means. That's a reference to a small chapter 11. There's a liberalized procedure. The debtor doesn't have as much paperwork to do on a small reorganization, which is chapter 11.
Okay, she corrected herself. So she meant limited chapter 11. So I guess the difference between chapter 5 versus limited chapter 11.
Well, there's chapter 11 and there's a limited chapter 11. The formalities of having a disclosure statement approved and a plan approved and the timing of it and all of the paperwork it has to do is limited for a debtor that qualifies for chapter 11 limited procedure. I went to a seminar on this and I have all the information as far as the qualifications for it. It's a streamlined chapter 11. Chapter 11 is very cumbersome. Tremendous amount of paperwork, and retainers can easily be a minimum $15,000 up front, $20,000. That's a good fee for an attorney, because once you file a chapter 11 bankruptcy, you don't get paid until you do all the work. You can get paid per month, but you have to work for it. And that retainer just sits there in your trust account, and you bill against it. You don't put it all away in your general account. And there's a lot of paperwork that has to be done, and you're not going to get a court order to release the funds to your general account until you've dotted each I and crossed each T. But in the smaller Chapter 11s, there's less paperwork to do, and the retainers are less to start.
Great. Next question from Charmaine Smith. What about the landlord? Do they have any relief to their ongoing debt service, expenses, etc., due to reduced non-existent rent? Reduced or non-existent rent?
The landlord have any relief?
Right.
Not that
Legally.
I'm aware of. That's negotiable with their mortgage holder. That's all I can say. It's negotiable, but there's
Okay.
no law that's. If you prove that you're not getting enough income from your tenants, you don't have to pay us. There's no law that says that.
Okay. All right. Next question from Jason Luros. How much effort does landlord need to engage in to avoid a failure to mitigate defense if landlord seeks the full amount of rent in an unlawful detainer proceeding?
Okay. Before the virus, there's statutory law that says if there's an eviction action, you can only sue for the back rent and the rent that becomes payable through the date of trial. It doesn't cover the balance of the lease, the prospective rent. That happens after the unlawful detainer action is over. Then the landlord can sue for a money judgment for the full amount of the back rent, the full amount of the rent owing under the lease, prospectively. So it's a 5-year lease. There's 4 years to go. The landlord can say, well, you owe me the full amount of the rent now for the whole term of the lease. And the tenant has an affirmative defense and says, look, I don't have to pay you if I can prove in court by a broker, I hire an expert witness, that you could have mitigated your losses. You could have done that by reletting the premises to another tenant for the same or higher amount of the rent. And if the tenant can prove that in court by expert testimony, then the tenant gets out of having to pay any money for the balance of the term of the lease. And if the lease has an attorney fees clause, any of them do, that's not limited to $5,000, for example. Most of the new ones are limited. The tenant will prevail and get a judgment against the landlord for the attorney fees that the tenant incurs in defending that. So that is a risk that the landlord, when they go ahead and file that action saying, well, I'm going to collect all this rent, and the tenant has a good witness to say, no, you could have relet the premises, can come back and hurt the landlord. They have to think twice about that. Okay.
All right. Next question from Shannon Marr. Pete, do you see any future rent relief legislation from Congress before or after the elections or eviction moratoriums? What about the state of California perspective?
Well, let's talk commercial and then residential.
Okay.
As far as reduction in rents, excusing people from paying rent, other than case law, affirmative defenses, which goes to court, I don't see the legislature saying we're going to let people out of the rent that they owe. So far, it's all you can't sue, and landlords are saying, well, okay, all the rent that's accumulated and going to accumulate, we'll enter into a deferral agreement with you, which pretty much says you're not getting out anything if you can afford to pay it. I don't think legislatures are going to come down and say generally that there's a 50% reduction or 25% reduction in the amount of rent that you owe. That may happen, our economy gets real bad, the legislature could do that because they realize there's no way tenants are going to be able to begin to pay that back rent, if any of it. And they're going to force tenants to bankruptcy, and the legislature doesn't want that. So that's an economic decision that the legislature will have to make downstream. Where are we going to be in March of next year, hypothetically, with all this accrued rent and the tenants barely surviving and not being able to pay it? I think ultimately there's going to be some forgiveness, to answer your question. But right now and before the election, I don't see anybody stepping out and making that decision.
Okay. Yeah, sounds like they still just got to work it out amongst themselves first.
Yeah.
Okay, next question is from Patricia Carroll. And it says, what do you think would be the possibility of either the state or the federal government that they would step in for both tenant and landlord relief? I think that's a similar question to the last one.
Yeah, as far as tenants are concerned, I'm sorry, residential tenants, I think there's a lot of sympathy for those that can't afford to pay because they lose their household, they lose where they're living, and we don't want them out on the street. So I think if there's going to be relief, I think it'll be to residential tenants first, and once that's done, then commercial tenants may get relief. Commercial tenants always seem to have deeper pockets and can withstand the economy better than a residential tenant. They don't have to worry about where they're going to live. And
Okay.
We have bankruptcy, so much for that. Okay, next question.
All right, next question is from Heather. Have you seen any insurance company approve business interruption coverage for businesses during this pandemic? We have heard the virus excludes any coverage from business insurance. I guess during the pandemic, are they accepting these requests?
I haven't seen any. I haven't heard of it. Insurance might cover the pandemic. It depends on the wording of the insurance policy. I would think the insurance carriers and underwriters probably have an exclusion for this. It may not say COVID-19, but there may be a similar language that may be utilized to prevent the tenants from realizing that you got to read the policy and see what it says. And then you got to talk to an attorney to interpret what it seems to say and see if you can get the money.
Yeah, I just can't imagine. I can't imagine any insurance company accepting that now. I mean, they would be taking on a lot of liability up front before they even collect any premiums. So that would make sense business-wise.
Since the COVID came about, that anybody is insuring it. These are older policies that may kick in, but I doubt if anyone's covering that now. Of course, you can always have a rider, pay more for it, and get coverage for it. Mm-hmm. Companies are, you give them enough money, they'll insure just about anything.
Yeah.
Okay, good.
All right, next question, again from Shannon Marr. Pete, early on in the pandemic lockdown in March and April, all the courts which normally hear unlawful detainers shut down. Are they reopened and hearing UD filing nows? How are they backlogged now? I guess go answer the backlog question because I think you already mentioned they're open.
They are open. I don't know how fast they process the cases now. There's probably a backload of cases that needed to be filed and are now being filed now. So who knows? It conceivably could take up to 3 weeks before you know if your case has been filed. There may be inherent delays in evicting tenants. From the time you file, normally you got to trial within 30 days. Sometimes as little as 20 days from the time of the filing, you had a trial, jury trial or not. And then once the judgment is entered and a writ of possession is given to the sheriff comes out and gives a 7-day notice to the tenant to vacate. But there's been a delay, always has been a delay between the time you give the writ to the sheriff and the time the sheriff goes out and actually enforces it.
Mm-hmm.
As well as enforcing collection on bank accounts. So if you're a landlord or landlord's attorney, you want to call the sheriff and says, how long is the delay between the time I give you a writ of possession or writ of execution and when you're actually going to work on it? And say, how long is how many feet of paperwork do you have before you get to mine? And they should be able to give you an answer to that.
Okay, so you haven't heard, I mean, obviously it's only been maybe a week. Have you heard anything anecdotally as to how long the backlog is from any other attorneys or?
No, I haven't heard anything. It's so new, I don't know.
Okay.
But anticipate that I had one, it took over a week to get a summons back. That was a couple of weeks ago. So that was on an unrelated matter.
Got it. Yeah, so I would just say
I would say that there's probably a delay. It could be a week or 10 days before you learn that your case has been accepted. It'll be deemed filed on the date that they receive the papers, but you won't get conform copy date until later. It says on the top of the paper, filed such and such a date, effective, and then they have an earlier date. That's stamped on the paper. That's how they do it. Go ahead.
Okay. All right, next question from John. If the claim is between $43,000 to $96,000, what is the estimated soft costs such as legal fees for the actions?
Why were those numbers chosen? 40?
He probably has something personal or within their business that is dictating those numbers, my assumption.
Well, a lot depends on whether there's a jury trial. There's really no need for a jury trial in these cases, but the tenant is entitled to have one. Problem with attorney fees is some of these law firms, they have astronomical hourly rates, over $400 an hour. And they submit their attorney fees claim in the form of a motion for attorney fees after the trial. There's a procedure. So within 30 days, there's a motion for attorney fees. And a lot of times, the judge will just rubber stamp it. It can be outrageous on its face. If you're on the losing side, you have to defend against the outrageous claim, and you have to take each particular item and say this is unreasonable in the amount of time to do that particular task and knock it down by 50% or down to 25% if you're really lucky. A lot depends on the judges. The judges don't like to spend the time going over attorney fees billing. So they're reluctant. So you really have to threaten an appeal of the judge's ruling if they don't apply their discretion properly. If they just ignore it, that's an abuse of discretion. You have to force the judge to go through the bill to make sure that they knock out the fat.
Okay.
Next question.
All right, next question from Craig Lieberman.
Hold on.
Okay.
As far as the amount of attorney fees, I've seen cases where the attorney fees asked for are greater than the amount in controversy in the underlying case, and the fees have been awarded. Now, that's not unlawful detainer, but I've seen HOA disputes where there was an $80,000 dispute and one side won it, and they had to pay $120,000 in attorney fees. They got $120,000 for winning that particular case, and there's only $80,000 at stake. So when does the hourly work that the attorney does, when does that become unreasonable in light of the amount in controversy? There's no control over that. And I've written on that issue to the bar, and no one's doing anything about it.
Yeah, there should be some sort of limit, you would think.
You would think. Go ahead.
All right, next question from Craig Lieberman. My understanding is, at least on residential income properties or residential income property loans, maybe also commercial property loans, is that the landlord can ask any federally backed lender for 6 months forbearance and then ask for another 6 months forbearance, so long as the landlord is barred from evicting any tenants during the forbearance period. You know if that's true?
Yeah, that's under the CARES Act. That's there's relief to the borrowers on that. You need to go online under the CARES Act and print that out and copy it. That's going to help you if you owe money to a lender.
Okay.
That's true.
All right. Great. Good to know. Next question from Jason Luros. If Prop 15 split rule passes, how bad do you see triple net lease defaults potentially getting over the next few years?
I don't want to make a prediction on that. It depends on the rates and the economy. You can see where things are moving, and you can see influences and potentials. But as far as giving a definitive opinion as far as how many businesses are going to go out of business, I wouldn't want to get close to that. A lot can happen from now till then. Any harsh result can be mitigated. We have Trump saying to tenants, you don't have to pay your rent through the end of the year. If you make $99,000 or less, and there's 3 or 4 other ways you can avoid paying the rent. But when the year is over, you still owe all that rent. So owing all that rent next year, that's where the play will come in. And as far as tax consequences, I think the legislature is not going to want to put people out of business by passing tax legislation. That defeats their own purpose. So we'll see what happens.
Okay. Next question from Shannon Marr. I guess the UD backlog will be learning as well as we go here, like all COVID and 2020 as a whole. Makes sense. Okay, that's just a comment. Next question from Mark L. Teen. If a restaurant tenant was behind prior to COVID, received 3-day notice and voluntarily returned possession, leaving guaranteed personal items worth 1/3 of owed rent, still owes rent, refusing to pay with excuse of COVID, and they voluntarily return possession, what remedies does the landlord have to collect balance? That's a lot to digest.
As far as personal property items left or abandoned, the landlord has to, I believe, auction them off if they're worth over a certain amount and apply the auction proceeds to the rent. If there's anything left over, it goes back to the tenant. The tenant is vacated, so the landlord can sue for the full balance of the rent for the rest of the term. There's a guarantor. It's very similar to the problem, a hypothetical that I just mentioned in my presentation here. There's a significant downside or the tenant that leads. And there's nothing left to negotiate or work out. It's just he owes a whole lot of money. The landlord can sue for the full balance of the rent owing on the rest of the lease. And at this point, be confident that he won't need to mitigate those damages, because it's impossible to find another tenant that will pay that amount of the rent, cover the rent. No, because you can't find a tenant to come in COVID.
Yeah,
so the
and
landlord is sitting. Go ahead.
I'm sorry. And I would think, based on this example, if everything happened pre-COVID, I don't think any of the COVID excuses would apply, because they were already out before.
Well, the frustration of venture, impossibility of performance, may be able to, that can be asserted as affirmative defenses to the unlawful detainer action. And the court could conceivably say, okay, we're letting you out of the lease because due to the closing down or the virus, you were unable to make the rental payments for those 3 months. And it doesn't look like anything's changed or will change for you. So we're going to let you out of the lease, or we're going to let you out of 6 months worth of lease payments. There's a lot of play there. This is where compassion comes in, and this is where the court can rule. There's a lot of discretion there. So okay. I would say those affirmative defenses need to be argued by the tenant vociferously and used as a negotiation as a negotiation tool to get the landlord to back off and say, okay, I'll agree on this. All right.
Okay. So in this example, so we also got some new information from the attendee asking the question. So let's say the example, the tenant left during COVID, even though they were behind on rent, let's say up till March or so, and then they didn't actually leave until July.
All right.
Would that change anything?
Well, the test of whether the lockout and or the downturn in business income is the same, whether they're there or not there. If they elect to move out, they're electing to give up. And of course, the fact that they can't operate is a defense. So whether they move out or not, it shouldn't affect the rent that's accrued up to that point.
Okay, so I think maybe whether or not they're able to open during certain months might play a factor. Do you think that'd be the case, at least for those few months?
Well, whether they're open or not is a factor, but it's like it's $8,000 a month, and they need at least $4,000 a month income to keep their doors open, and it's not coming in, or no one thinks it's going to be coming in for 6 months. I think they have a good defense to not paying any of the rent or getting a substantial reduction in rent from the court.
Okay. All right. I think we have. I'm sorry. We have one more question. Okay. And that is, are you aware of any class action lawsuits by tenants or landlords against insurance companies for business interruption insurance denials?
No, I'm not aware of any. Class action, I don't. Class actions are tough to keep in a class because the effect of what you're alleging has to be the same to each class member. The dollar amounts are different. Each policy is different. I don't know if a class action could be architecture for it. It's possible. Look, some large firms, all they do is class actions. And if somebody's interested in that, you need to contact one of those firms and see if you got a claim. If they think they can make a class action out of it, great. I don't do class actions.
Okay. All right. We have one more question, and this will be the last question since we're already at 12 o'clock or beyond 12 o'clock.
Okay.
And this question is from Heather. Landlords are claiming impossibility of performance and force majeure are not applicable. Oh, this might be a comment. Majeure are not applicable during this pandemic based on their discussions with attorneys because food and beverage are allowed to be open for takeout. Do you agree?
No, because you don't have the foot traffic for takeout, and you don't have the business volume for sit down. And then even if you can sit down, they have limitations on like 25% capacity. So yeah, you can still keep the business open, but you're not going to be making much money on it. And if there's a tremendous volume of takeout, then I would agree, could agree with that argument. Like Arby's near me is closed other than for takeout, but they have long lines there during lunchtime, so they're surviving.
Yeah, so maybe a better example would be, so, I've heard some pizza and takeout specific locations are actually making more money now than they did prior, but are still claiming that, this is an issue where they can't pay the rent, even though, on the books, it probably shows that they're making more money than before.
Well, then they're lying.
So I guess at some point they're going to have to pay up.
Well, I can't pay the rent. And the landlord says, "Let me see your financials. I want to see your bank statements. I want to see your bank ledger. I want to see your monthly income and expense statements. I want a copy of your balance sheet. I want the same information from your guarantor, and I will flesh all that out. So don't lie to me. Don't think, if you're a tenant, don't think you can get away with that."
Okay, got it. Well, that was a lot more questions than I anticipated, but I'm glad we got through all of it. Pete,
Okay.
Thank you so much for taking the time to brush us up and give us all the new information on what's going on with landlord and tenant law and evictions, etc. If you guys have any questions, we had the slide up with Pete's contact information, so feel free to give him a call if you need anything. And want to thank you again for your time and your knowledge and your experience. We're very grateful for it. Thank you so much. Any last words, Pete?
No. To put on a presentation, it generally takes 3 hours for every 1 hour presentation time. I put in 6 a couple of days ago. I had a lot to read, a lot to digest, some of it historical, and some of it very current. So this is fairly complex stuff. You got to stay up on it. I get updates all the time. I'm an attorney, but there are sources for you to stay up on this, and make sure you do, because mistakes can be made. One other thing, I understand that the giving of 3-day notices in the future for tenants, you can give a 3-day notice. You can't sue for residential tenants. When you give the notice as a form, it's an unsigned declaration form for the tenant to fill out saying that I haven't been able to pay my rent because of the virus. That's part of the 3-day notice. If you don't include that in the 3-day notice, your 3-day notice is invalid. Just thought I'd tell you.
Okay, that's good information.
That's on residential, yeah.
Okay. All right. Well, thank you so much. And we want to thank our sponsors once again, CoStar, Sperry Commercial, Sharpline, and our silver sponsors, Rexford, BP International, our RPM, CJM, Wells Fargo, Gaynor Page, Comstack, Asset Preservation, SVN, Fidelity, Capital Direct Market, or Capital Direct Funding, JP Morgan Chase, and our bronze sponsors, Green Economy, MW, Fed Receiver, and George Smith Partners. Thank you all again for attending our webinar, and we'll see you next time. Take a look at our website at ccimla.com for a list of events. Thanks, everyone. Bye.
Hey, David. Bye-bye.
Thank you, Pete.
Okay.